The first case to come before us is State of Ohio, City of Akron versus Franklin v. Ragsdale III. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. Louis Grube here on behalf of the defendant appellant, Mr. Franklin D. Ragsdale III, and I would like to reserve 3 minutes for rebuttal, please. May it please the court. Mr. Ragsdale interfered with and obstructed nothing more than the unlawful backlash by Akron police against protests that they did not like. He committed no crimes because police officers lack lawful authority to arrest those who criticize them, or to simply seize vehicles driven during the commission of minor misdemeanor traffic offenses. He asks this court to discharge him. I'd like to briefly start with the speedy trial issue, just because there was some dispute over the record. The record's fairly bare about the justifications for continuances. I'd just like to remind the court that my client has a prima facie case to make on speedy trial, and after that, any justification for continuances that push trial off, that the burden for that falls on either the state if they've requested the continuance, or the court if the court continues on its own motion. And we have 3 continuances at issue here, each of which fall into those categories. Moving on to the yes.
In your appellant brief, you seem to be focusing on 3 issues on speedy trial. One, the tolling that started, the state's like it's the tolling that started from the time the court was closed because of the protests. They want that to start on April 10, and you dispute it should start on April 10.
We dispute that the court was even closed.
Well, yeah, a couple. You kind of have 3
Sure.
things. So one is kind of we dispute that. 2, then you kind of dispute after that, the continuance on the 18th or whatever happened, if I understand. There's no basis for that at all in the record. And then the 3rd thing you're disputing basically is the June 28th order.
Yes.
That's the main issue that you dispute. Does the record ever show when the June 28th trial was set?
I think there's a handwritten, it's like so the municipal court records are, obviously there's a lot going on in the municipal court. So I think that was set on the folio. There's like a handwritten annotation, if I remember correctly.
There's a notation. What we have in the record, the front page of the file shows the trial date of June 28th being set.
Sure.
But it doesn't tell us when it was set. Was it set at the February 2nd or 3rd pre-trial or the February 23rd?
I don't know offhand. I was not trial counsel in this case. Okay. I can tell you though that I do think the record is silent as to that question.
There's a allegation that there was a email sent on 4/21 by trial counsel requesting a continuance. Does that appear anywhere in the record?
I have not seen that anywhere in the record.
And if those things aren't in the record, what's the significance of that to you?
I was prepared this morning to compare it to the absence of evidence in the record going to an element of a crime. I mean, my client doesn't have a burden to prove definitively that tolling didn't happen. My client has the burden to prove that the time went by, it was too long, and then the burden shifts. There's a very established burden shifting framework here. So, if the court wants to say that it needs 50 more days to go to trial in June, it needs to establish why. I mean, we said 2 weeks. I want to be generous to the municipal court. I of course understand it is hard to run a municipal court. There's a lot of folks coming in and out every day. You don't know what's going to go forward. But all we were looking for in this case was an extra day for trial. 50 days, I mean, that's, at some point it's a bridge too far, and we only need to count to 28 days here. So even if this court says 2 weeks, that 2 weeks at the end, like the end of July, beginning of August, plus the 15 days that weren't actually a continuance for the non-court closure, I suppose. We just need to add up to 28 days. So I think this court has plenty of room to be, deferential to the needs of the lower courts while also explaining that at some point we've gone across the bridge too far.
Is there some case law where if the record is silent, then it's presumed charged to the state?
Well, no, I mean, there's nothing clear that I've been able to find in that regard. I think we're relying on the burden shifting framework, which is clear in its own way. I guess the point is, if the state wants to say that some time was countable or was not countable to get out of the speedy trial dismissal, they need to lay that foundation. So we don't have the email. We don't know when the initial trial date was set. We don't know that anything needed to happen during the work from home order for the municipal court. So, in any case, I would turn to the sufficiency arguments because I think that's the fun meat of the case actually. We've got two instances where it's fairly clear that the police officers wanted to take it out on folks who were assembled in public. Perhaps they should have left. But on the first instance, we've got this parking lot situation where not even my client, another gentleman, starts swearing at the police. He's raising his middle fingers. He's criticizing the police for what they're doing. These are very famously protected speech.
Well, it seems to be the case law, it kind of depends, if you will, in that some of the case law that you cite is an individual making a obscene gesture to an officer when there are other folks around. And certainly in those instances, the police need to have thick skin, and the courts have said that's not sufficient for disorder. But when that same context, the same action occurs in the context of a large amount of people being around, there's some level of concern about crowd control and other things. Our court, and I recall one of our cases, what we have said, that's sufficient for there to be disorderly conduct against Mr. Brown, and that leads it to be in a court resisting arrest here because your client charged with resisting, not the actual conduct himself here on far as resisting. Go ahead and explain how that, in your view, that discrepancy, how we deal with that.
Are you talking about the Stanley case? Is that?
Yeah, I think it's our Stanley case.
Right.
And some of those cases that is dealing with that.
So Stanley was a situation where an individual in a car driving by a melee. It was described as a melee. These are citizens fighting, 50 to 100 people, already in a brawl that police are trying to get under control. This court did not say that that was an arrestable offense. This court said that's enough for a Terry stop. We don't have a Terry stop here. This was a full custodial arrest of Mr. Brown. That is categorically different. The standards are different. That is enough to distinguish it. But moreover, we've got a situation in Stanley where there are 50 to 100 people. There's already fighting going on. There's already violence. Call it what you will, but nobody can say that there's an emergency, a fire, anything going on at the parking lot location that would justify, this level of arrest. Everything that happened in that situation was a minor misdemeanor at best. And notably...
Well, it becomes the disorderly conduct, assuming Mr. Brown committed disorderly, it becomes M4 if he did it after he'd been warned to desist. And the argument is the prosecutor is they were told to desist, everyone told to desist, and he kept on doing it. So it became an M4, which is arrestable.
It's a little bit more subtle than that, because the city's saying that they were told to disperse. The city's not saying they were told to stop swearing at the police. And in any case, I don't think you can tell people to stop swearing at the police. Again, it's protected conduct. So we're not only dealing with a constitutional limitation, we're dealing with a limitation of the facts. Again, that's why this is a sufficiency case. Nobody told them to stop flipping off the police, calling them pigs, or using the F word. And that's key.
They did tell him to disperse.
Yes, they did tell them to disperse, but even persisting failure to disperse is not an M4. Failure to disperse is only an M4 if that emergency, fire, if that standard is met. And again, there's nothing like that here. This is just a group of people inconveniently in a parking lot.
Well, my understanding from the briefs was there was evidence that they were blocking officers from leaving.
There was one individual who was blocking an officer from leaving. That person was arrested without incident. I mean, the city's trying to say that all of this pins back to that person standing in the way. And I mean, call it what you will, but somebody standing in front of a police car as it drives slowly through a parking lot is not an emergency. I mean, it's inconvenient. It's a reason to arrest that man.
But if you're ordering that people to disperse because you can't leave, wouldn't we be in arrestable misdemeanor territory?
No. Persisting failure to disperse, that is not a misdemeanor until you've told them to disperse, they continue to do it, and there's some serious concern for an emergency. If you look at that statute, there are elements in subsection A that are absent from the M4 section at the end. I think it's subsection C. If you're causing an annoyance, if you're continuing to cause an annoyance, if you're allowed, and I'm not trying to undermine the city's legitimate need to rein in control over this parking lot, but the police officers did not get out and start writing tickets. They did not write 4 tickets and then it's an M4, because at that point you've violated the law a number of times.
What about being close enough officers to be able to grab their weapons.
Yeah, I mean, I don't see that on the video, but also these people were not under arrest.
So
They're
was
not
that
suspected of any
was
crimes.
that part of the testimony then, from the officers?
Yeah, the officer said somebody was within 1 foot, but I mean, who has control over that? These are police officers who are entering a space that is already occupied by people. I mean, I don't want to, again, I don't want to minimize the concern for officer safety, but there's no freestanding right to arrest for officer safety. There's a Terry stop, potentially, but only if you're investigating some crime with reasonable suspicion. I mean, this truly is a case where every justification for this arrest is flailing, fails to meet the law, has inadequate evidence. Truly the parking lot incident is not an arrestable level event. And even, I think the best example is one of these police officers got on the stand and testified that people got so close to their cars that they hit the mirror, the side mirror. I mean, imagine if you ran into somebody and then tried to blame it on them. No, I'm sorry, they were in my way as I was driving through. We don't treat pedestrians like that. I mean, I guess the fabric of time and space is warping around these police officers with their explanation about what's going on. I had a really hard time following it, but I think there's a bigger point, which is that actually all of this is pretextual. Sergeant Sterling said very clearly that he was there to suppress what people were saying about the police. He said he needed to show force to a main agitator. I mean, straight out of Soviet Russia. Straight out of Soviet Russia. This was a backlash against people's frustrations, reasonable frustrations about the police. Disagree with them all you want. People were upset at the police in Akron during that time period. They did not want to hear it from the police officers. They did things that are constitutionally protected in terms of speech, and that is the only thing that my client interfered with. Very similar situation with the car tow case. They were told to tow that car before it ever made it out that day. They were told to tow that car before the protest even happened. It was because the Akron police were upset about the protests. They didn't like what people had to say.
Well, the protests were, I think, as I understand the prosecutor's argument, the protests were going on, they were interfering with traffic in Akron. People were deliberately trying to interfere with traffic. And then that was their protest, that's what they were doing, that's
Sure.
what they could. But there could be consequences to that too, if the police decide that some form of reckless operation. And they could charge them. So these had happened before. Is it inappropriate for the officer to say, okay, these have happened before. If this happens again today, we'd like to handle it this way.
Yes, it's inappropriate to handle it that way by towing the car. You can't just seize property. That's all of the case
Now,
law.
the Blue Ash, you don't refer, they refer to Blue Ash Highway case. You don't refer to that in your response at all, either in your brief or reply to that, where there was a caretaking function for someone who was arrested for charged with reckless ops, and they towed the car. And the police said that was permissible around the car. How do you distinguish this from Blue Ash?
Yeah, so this was not a tow incident to arrest. The owner of the vehicle was standing right there complaining about her car being stolen. The gentleman who was driving it was not ticketed with an arrestable offense. He was ticketed with a minor misdemeanor because probably the police officers realized in their vehicle with real-time data on this person's priors that they didn't have enough prior reckless ops in order to raise it to an M4.
You're into your rebuttal time.
I would like to reserve. This is a great conversation, but I appreciate the court. Thank you very much.
Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of the state of Ohio and the city of Akron, which is the appellee in this case. And there are 3 reasons to affirm Mr. Ragsdale's conviction and sentence. First of all, because of tolling events that do appear in the record, at least through the reply that the prosecution made to Mr. Ragsdale's last-minute motion to dismiss on speedy trial grounds, there were legitimate tolling events that added up to Mr. Ragsdale going to trial nearly a month before his speedy trial time expired. Second, the city did meet its burden of production on all the elements of the offenses for which the jury convicted him. And finally, his offenses could not merge for sentencing. And I understand that counsel throughout the trial and again in this appeal has focused on the conduct of police. But but this court, again, has to look at all of the elements and all of the evidence that was before the jury. And both the arrest of Mr. Brown for the 2022 case and the towing of the vehicle in the 23 case were legitimate acts of the police. And Mr. Ragsdale admits that he did every other element of both offenses. He did stand in the way. Now, regarding Mr. Brown and resisting arrest and the obstruction of official business from the 2022 case, Mr. Brown was not a champion of or a hero of the First Amendment. He was not arrested for merely cursing at police or flipping them off. He was arrested by police because he himself had acted to impede the arrest of a third person who was blocking the police from being able to drive through that parking lot. And I would like to remind the court that the police went to that parking lot not to break up a protest, but they were drawn there because there were reports of a fight occurring at that parking lot. That's why police went there. And it was between around 2 or 4 o'clock in the morning. That area is also, in addition to being a commercial area, it's also a residential area. And all the people that were gathered there were loud, disruptive, and were causing annoyance to the folks who live around that area. So again, Mr. Brown interfered with that third man's arrest. And also, Mr. Brown wasn't just cursing at police, he was riling up other bystanders to interfere with police. There was testimony that he was one of the people that got within a foot of police officers to a distance where he could have seized an officer's weapon. And when he hindered the officers' efforts to get the noisy crowd to disperse, that's why, really, that police decided to arrest him.
So I understood your brief to be arguing that Mr. Brown was engaged in disorderly conduct and it became arrestable as an F4 because he was given a warning to disperse.
Correct.
You're also saying he was being arrested that day for resisting now? I don't know that I understood that from your brief.
No, I'm sorry, I did not mean to give the court the impression that he himself was resisting, just that he had interfered in some ways with the arrest of a third person or distracted.
It's all disorderly conduct and not some form of that interference, but raised to the level of resisting arrest as well as disorderly conduct. So,
Correct.
okay, just want to make sure your assertion is disorderly conduct for him.
Correct. It limited just to disorderly conduct that, you're right, rose to the level of a 4th degree misdemeanor. In addition, he was also one of the people who was ordered to disperse that night as a result of the police being there for a fight call. And
how were the folks warned to disperse it in this case?
The officers told them it's time to go home, leave, repeated that, on the videotape.
Over the loudspeakers, or were they doing over loudspeakers or just in the regular voice and tone?
I think a little of both, Your Honor, if I recall the video correctly. So this is not, Mr. Brown is not like the Stanley case in Kent where he's merely making a gesture, okay? Although the Stanley case from Kent, which was an 11th district case, Mr. Stanley was the driver and his passenger was making a rude gesture to a group of people outside a Kent bar where they were already fighting, and the police pulled him over, Mr. Stanley over, because of the actions of that person. Actually, I should say Mr. Brown's case is like the Stanley case in Kent. He was like the Stanley case. He was riling up a crowd. So he was not only refusing to disperse himself, but he was also urging other people not to disperse and causing them to continue to be disruptive. So this wasn't just a fighting words case where the allegation is that the police don't like what Mr. Brown was saying. There's a line between speech and action, And what Mr. Brown had done crossed that line between speech and action. Action is prescribable, and what he did was he continued to rile up the crowd. He got in the face of police in a way that made them concerned for their own safety and the safety of others, and he, to the extent that he distracted from that third man's arrest, he also interfered with their lawful activities. So therefore, they had grounds to arrest him for a fourth-degree misdemeanor. Then Mr. Ragsdale's act of purposefully stepping in front of police and using his body to interfere with their ability to apprehend Mr. Brown was what constituted the resisting arrest. In addition, that could also be obstructing official business, but also there's additional evidence that Mr. Ragsdale acted to distract officers when they had already tased Mr. Brown, and Mr. Brown was being lifted up by police. Mr. Ragsdale was among a group of people who surrounded police and were acting to distract them from their assistance of Mr. Brown and their furthering of the arrest.
I would like to draw your attention, I appreciate your argument on that issue, but we have a limited amount of time.
Yes, sir.
On the second case, the 2023 case.
Yes, sir.
I'll refer to that. What was the lawful activity that you allege Mr. Ragsdale was interfering in? The lawful duties of the officers?
The lawful duties of the officers were processing the car that had been driven away to Jennings, what used to be Jennings Middle School, and then to, again, on a second instance, to the Swenson's headquarters, and then finally to the Stonehenge location.
If I understand the defense's argument, it is that those weren't lawful duties because the car did not need to be towed for a minor misdemeanor reckless operation offense. Under what right here did the city have to tow these vehicles under reckless operation offense?
Well, that is part of the city's policy. In addition,
Do they tow for every reckless operation offense?
I don't know that we tow for each and every one. I don't think that we do. However, we do have evidence in the record of policies by the city as to when they will tow and when they will not. In addition, there was an additional consideration of the fact that the place where this car was driven from by the officers was a gas station parking lot. And I think that the vehicle, if I recall the video correctly, was actually at a gas pump when the police got into it. And that was a relatively small lot. There were lots of people there, and so for the reason for driving it elsewhere was to get it out of there. But it would
Well, I
also,
think the defense's argument, he was charged with reckless off, give him his ticket and let him go on his way. Why was it inappropriate for the police to do that in this particular case?
I think because of the other concerns that the police had about, how long would it possibly take to get the odor there, to drive away, a licensed driver who wasn't being placed under arrest, and the circumstances of, we have some testimony, like I said, about the smallness of the lot. You can't have, if the police were going to be ticketing every car that came into that gas station, there were several that were part of that convoy, that if they ticketed all of them and left them all there where they were for any length of time, it would wind up being a community caretaking problem.
Well, isn't reckless off on public property misdemeanor of the fourth degree, not a minor misdemeanor?
Yes,
So then it would be an arrestable offense.
yes.
And are the police allowed to tow any vehicle that's an arrestable incident to arrest?
Yes, they are. They are. As long as it's not, of course, a pretext for a search, which there's no evidence in this record that it was a pretext for a search. And I would like to make one final point about that Mr. Ragsdale appears to be trying to vindicate rights that aren't his. And there's no real clear case law on whether somebody in the situation can interfere with the seizure of a car that is not theirs. You know, it's as if he's trying to vindicate the Fourth Amendment rights of a third person. And Fourth Amendment rights, of course, are personal, they're limited to the person involved. So there's a question as to whether he would even have standing to assert that the acts of the police were not legitimate regarding, or under the Fourth Amendment.
Wouldn't one of the elements you'd have to prove, though, that police were engaged in lawful duties, and if this is not lawful to tow someone's car in a certain circumstance, you wouldn't meet the element, without getting into the whole Fourth Amendment question? And who has standing?
Well, a lawful, I'm sorry, I'm looking at my notes. I think so long as the police have reasonable suspicion or reasonable grounds, then that would make the seizure of the car lawful. And it would then be up to the person whose vehicle was seized to assert those rights.
And moving to speedy trial,
Thank you.
is there any order ever setting the June 23rd trial on the record?
Not among the documents that became part of the record that came before this court. There is a notation, and that's about it. However, there is some evidence in the record in the form of the reply that the state provided to Mr. Ragsdale's last-minute motion. And none of that was ever rebutted, which Mr. Ragsdale had a duty to do. You know, a defendant
Well,
has...
the court ruled on like the next day or so, didn't it? You filed your motion, they made the oral motion, they filed that, you filed a written response, and I think the next day or two, the court made an order saying, I'm denying the speedy trial to that motion. So what time was there for them to reply?
About the same time that the city had to respond to...
Well, the court waited. I mean, normally you'd have 7 days, the court didn't wait, they made the ruling. I'm not objecting to that, but to say they should have rebutted, the court didn't wait for the rebuttal time.
Well, the problem was that this motion to dismiss on speedy trial grounds was made on the morning of trial. So the city only had that evening to draft a response and turn it in. And then the court could look at it and rule on it. But, you know, having received that from the city, the defense could have orally, at least, or put into the record in some way, you know, Judge, I don't remember this being the way that it's been represented in the city's response. And in addition, you know, there is case law that presumes that when a defendant does not make a timely objection to a continuance, that the reason for the continuance is reasonable. And that's pretty well established in the case law. For instance, in...
But on our record, how can we say anything occurred? The record is completely silent on motions were granted. We don't know if on April 18th there was a continuance granted. We don't know on the 21st if there was a continuance from the defendant. We don't know on February 2nd what occurred, because there's no notations at all anywhere in the trial court's record as to people making motions, why things are being continued. And now I'm going over time, but if Judge Lindsay would permit it, please respond to that.
Well, that could have been remedied in this case. There is the opportunity, even if a trial court provides an inadequate record, there is an opportunity through Appellate Rule 9 to supplement the record to indicate what actually, or additional details of what happened. There was also the opportunity to request transcripts of every pretrial that was held to determine who asked for what continuance. That was not done. And I would remind the court that when it comes to an appeal, it is always the appellant's duty to bear the burden to show that there was error to the court, not the appellee's duty to say that there was not.
And your time is up.
Thank you, I urge you to affirm.
You have a little over 2 minutes.
Thank you, Your Honor. I'd like to start with your question first, Judge Langier. I just looked at the statute for reckless stop, 451120, nothing in there about M4 on public property. It just says it's a repeat offense. I think you have to do 3, and then your 4th one is an M4. So if there is some property element, I don't think it's for reckless op. Again, reckless op was the only theory for why this car should be towed. I don't know what happened in this case. I don't know the gentleman who was arrested, who was the driver. I don't know what happened in this case. I'm stuck today with the case that I have. My client was convicted of a crime, and he has standing to challenge whether the evidence adequately supported that finding of guilt. The elements go to the lawfulness of the police conduct, so I don't need to actually vindicate anybody's constitutional rights. I can sort of just wave generally at them and make good arguments about how the police were overstepping their boundaries and explain to this court why actually there was no lawful police conduct and therefore the crime was not proven. So only by escaping the framework of sufficiency can we get to that standing problem. Reasonable grounds for the arrest, that's an arrest issue. My friend here was arguing that about reckless op and the tow. Community caretaking, though, is not done attendant to an arrest. Community caretaking, again, so its own doctrine about nuisance, present nuisance, not a former nuisance. You don't use community caretaking to punish people. And pretext annihilates community caretaking. That was clear from the leak case. So, it matters that Captain Yogi called these terror convoys done in hopes of trying to draw attention to their message, and then ordered every car involved towed. I mean, come on. That's all I got. So with that, I'd ask the court,
So
yes?
do we really have a record of all the possible reasons that the officers could be lawfully towing a vehicle? I mean, wouldn't this, if we said that you could interfere anytime the police are doing something, one of their duties, that when people just vigilante go around and decide the police aren't performing a lawful duty and they're going to interfere?
Well, so the premise of the question was within their duties. And this is a case about whether or not they were within their lawful duties. So I'm not going to accept the premise, respectfully.
Well, I'm saying, do we have a record of that? Do we have a record that, like, did this person actually get charged with something with the car?
Yes, yeah, he was cited with minor misdemeanor reckless op.
And did we have is there anything else in the record about that vehicle? What's in the record about the vehicle?
Yes, they legally searched it and found a gun. Because he should never have been arrested. The driver was standing right there, so it didn't need to be towed. I mean, I would just point to the city's exhibit.
You don't have a suppression hearing on this issue, or?
Nope,
So,
that's not.
So it's just an assertion.
Well, and that actually, that question is interesting, because then that does put my client in, if you're asking why we didn't have a suppression motion, then you're asking why my client didn't try to vindicate the rights of
No,
others.
I mean, with the person who has the rights, is the car owner, right?
Sure, yeah, I mean, the state could have, or city could have absolutely made that a part of their presentation to go to the elements of the offense and chose not to. What we do have is City's Exhibit 5, which shows the driver standing there complaining about her car being stolen by the police. And that kind of encapsulates this whole part of the case. I think I've answered the question. I'm happy to answer any more questions, but we would ask the court to reverse
Thank you.
and discharge my client. Thank you.
The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of this decision as soon as it's released. The opinions are also posted on the Ohio Supreme Court. Thank you both for your presentation.
Thank you, Your Honor.